The official government website too stated that the 17th Amendment to the 1978 Constitution was a significant achievement of the democracy in Sri Lanka. In a landmark vote, Sri Lanka's parliament passed a bill on September 25, 2001 with a two-thirds majority to amend the constitution to establish independent commissions to administer the police, judiciary, public service and elections.
It's a start, and it's the first time that a citizens' initiative has been enacted in Parliament as a part of the Constitution.
It was far back in 1998 that the opposition initiated the citizens' consultation on depoliticization of key institutions.
රාජ්‍ය සේවාව දේශපාලකයන්ගේ අතකොළු බවට පත් වුණාම සැබවින්ම ඉතාමත් අවාසනාවන්ත විදිහට තීරණ ගන්නට පුළුවන් ශක්තියක් ඒ විධායකින් නැති වෙලා යනවා. මේ නිසා රජයේ නිලධාරීන්ගේ ස්වාධීනත්වය ආරක්ෂා ස්වාධීන රාජ්‍ය සේවා කොමිසමක දැඩි අවශ්‍යතාවක් තිබුණා.
We demanded that these independent commissions be set up, and I am proud that ultimately the instability that was created after my crossing over to the opposition and the courage of my conviction to remain firm in the opposition ranks have forced the government to concede this 17th Amendment.
ව්‍යවස්ථාදායක සභාව පත් නොකරන බව අතිගරු ජනාධිපතිතුමාගේ ස්ථාවරය වී තිබෙනවා. දැන් මේ ආණ්ඩුව අපිට කියන්නේ මේ නීතියේ දුර්වලකම් තියෙනවා. ඒ නිසා මේක දැනට ක්‍රියාත්මක කරන්නේ මේක සංශෝධනය කරලා අපිට හරියන විදියට සංශෝධනයක් ආපු දවසක ක්‍රියාත්මක කරන්න එතකම් මේ නීතිය අපි ක්‍රියාත්මක කරන්නේ නැහැ කියලා. ඒක නීතියට පටහැනි ප්‍රකාශයක්.
However, according to the government, the 17th Amendment to the Constitution for establishing the Constitutional Council is a failed legal document.
අලුදු දෝෂ සහිත නීතිමය අකරදැබ්බියක්.
The first duty on the president to implement the existing constitution. A president of a country or any other person cannot say that I am not going to implement the constitution till an amendment comes.
Sadly, the 17th Amendment to the Constitution has become a dead letter due to the failure to appoint the members of the Constitutional Council, which has, for instance, compelled a fast-aging commissioner of elections to continue in office ad infinitum and beyond even the compulsory age of retirement. In the absence of a properly constituted Constitutional Council, elections are now held without the salutary oversight of the Independent Election Commission sought to be established by the said amendment. And major appointments to the public service and the judiciary are made without complying with the mandatory provisions of the Constitution. It is therefore essential to bring about a change in polity and attitudes to create the climate for the appointment of the Constitutional Council so that it can begin to function once again. This is extremely important for the preservation of the rule of law in this country.
I know that the government has defined the issue as one of GSP plus or our self-respect as a country, as a nation, our sovereignty, etc. But I think the less confrontational attitude to this is possible, and both possible and desirable. As we have consistently maintained in our interventions into this debate, we have always said that we must use the GSP plus framework as an opportunity. Obviously, we have massive economic advantages out of this, particularly for our apparel sector, etc., but also for other matters. For example, like civil and international political rights recognized by international law.
Right.
What our argument has consistently been that we should use this as an opportunity to do a win-win solution.
Yes. Now, but then you and Rohan Singh and others have been advocating a constitutional, amendment because some of the rights that are in the international covenant are not guaranteed under Sri Lankan constitution. But, that is a drastic measure, don't you think?
Yes, I want to be very clear about that. There are two things that I want to say to you. One is that as lawyers, obviously, our critique has been this, and that our constitution does not recognize some of these rights, and to the extent that some of them are, not to the extent that they are guaranteed by international law. So what we have said is, ideally speaking, certainly a constitutional amendment would be the ideal way of doing it. And then certainly we saw at one point also that there would be no parliamentary opposition. The United National Party guaranteed that their support would be forthcoming for a constitutional amendment. So we are at a loss to find out what was the problem that the government had. Second matter, if I may just finish, is this, and that is that there are other ways, certainly, for the purposes of GSP+, for satisfying the EU that the government of Sri Lanka is serious about some of these things, that this could have been done. But we do not believe, nonetheless, that the two principal measures that the government has taken in this regard are satisfactory at all.
We want GSP+.
I think everybody wants
okay.
it.
So who is going to make the decision? The EU and the EC, right? So surely we must now focus on what they are asking us to do.
So what you are saying is there is enabling legislation already in place, and that there needs no amendment to the constitution and so on.
It's not I who am saying it. It's something much more important than me. It's the Supreme Court of the country which has exclusive jurisdiction with regard to fundamental rights. You see, because of this controversy, the President made use of Article 129 of the Constitution to refer this matter to the Supreme Court, which is entitled to do.
Yes.
Because there were different views expressed and there appeared to be considerable confusion, we basically asked the court, is the legislation now in force in this country sufficient to enable a person who is complaining of a violation of a right guaranteed by the ICCPR to seek a remedy in the courts of this country? Say the ICCPR recognizes the right of association,
right,
and I am saying that my right has been contravened. Now, do I or do I not have a remedy in the courts of Sri Lanka?
Yeah. Now, if
who can answer that question authoritatively? Only one person, the Supreme Court.
Now,
and they have said yes.
I have read that the ICCPR Act 2007, that only 4 substantive provisions are included, 2, 4, 5 and 6, and that some of the ICCPR rights are not recognized even by the Sri Lanka Constitution. In fact, Rohanadrisinghe talked about that. He said something about, the right to life and issues of right to compensation for unlawful arrest and so on.
Yeah, but Harsha, the fact that you have that sentence in a constitution, what does it mean? Does it mean because the constitution of Sri Lanka doesn't refer to the right to life, does it mean that people can be killed in this country lawfully? Not at all.
It's my pleasure to welcome Rohanadrisinghe on our show once again, coming back after about a year when we originally spoke about the GSP+. Rohan is senior lecturer at the Faculty of Law at the University of Colombo. Welcome, Rohan.
Thank you.
The last time we spoke, you articulated the issues with the Constitution. Particularly we talked about the ICCPR, International Covenant on Civil and Political Rights, the Convention Against Torture, and the Conventions of the Rights of the Child. Those are the 3 problem areas that were being investigated by the European Union in order to determine whether we could continue to keep GSP Plus or not. Now the report is out. They are saying, look, there are major problems in implementation of these international conventions, whether they are incorporated sufficiently in the national legislature and so on. Last week we spoke with Ambassador Savage, and basically what he said is, look, you people agreed to, live by these conditions, and we needed to ensure that everything was okay for us to renew, but you wouldn't let us, come here and do that investigation, because by doing that, the EU would be sort of violating our sovereignty.